I'd like to introduce today's speaker. Charlie Smithen is the Executive Director at the Iowa Public Information Board. He formerly served as an Executive Director for the Iowa Ethics and Campaign Disclosure Board, Chief Clerk of the Iowa House of Representatives, Legal Counsel for Iowa Secretaries of State Office. He is the contributing author to the book Money, Politics, and Campaign Finance Reform in the States. He is an adjunct professor of election law at Drake University and is a certified state election administrator. He received the Dwight Inc. Public Service Award in 2009 from Iowa State University. I'm going to turn it over to Charlie at this time.
Thank you. The worst part of the speech is over with because we got through my bio. I'll be honest, this is a very unique experience for me. I have never done a webinar before, so bear with me a little bit. It's kind of odd speaking to a room where I've got one person and she's going to pretty much be plugged out monitoring the technology part of this, so this is going to be a little unusual for me. If any of you have ever seen me speak before, you know I usually try to move around a lot, and I've been told I can't do that. So we'll get through this the best we can. If you do have questions, please type them in, because I'd like this to be interactive and help fill out the hour. Let me talk just briefly about the Public Information Board. It is the newest state agency. It was created about 4 years ago now. 3 people, 3 full-time staff, a board of 9. It was decided by the General Assembly and the governor that chapters 21 on open meetings and 22 on open records was important enough that we needed a state agency that was dedicated solely to regulating in that area, which is kind of twofold. One is, of course, we receive complaints from the public about activities of government. We deal with those the best way we can to resolve them expeditiously and informally between all the parties. And number 2, and what I'm going to pitch to you today a little bit, is we answer questions from what I call the regulated community and the public on what the law is. I would encourage all of you to go out and look at our website. We have a lot of information out there. I'd also ask you to submit advisory opinion requests when you get a chance. Those of you that worked with me during my time with the Ethics and Campaign Disclosure Board, we built up a pretty good body of answers where someone would ask for an opinion request and we would apply the facts to the applicable laws and rules, get an answer in writing, and then that was a way for everyone to kind of see how the board viewed certain situations, and you could act that way in the future. We've started issuing more of those advisory opinions at the Public Information Board. That is something I would really encourage you as an avenue to get answers to questions. With that, let's jump in a little bit. I know that with the recent ruling from the Supreme Court in the Warren County case, that's going to take up a little bit of our focus. So let's start with there a little bit on open meetings. First of all, in my written materials, you will not find anything on that particular case. This caveat 1, the Public Information Board has not made any rulings or determinations on kind of how that case is going to apply in the work we do. We have not had a meeting since that ruling came down last month. Our next meeting is April 21, and I imagine that they will start to talk about that process a little bit. So keep in mind that anything I say today is kind of my personal opinion. The board has not done a ruling on that yet, and I know that there'll be some questions. I can tell you it's been an interesting 2 or 3 weeks dealing with some of the stuff that I've heard from the public. I had one lady tell me that this means that closed sessions are now illegal and there'll never be another closed session in Iowa. We clearly know that's not the right answer. I had a city council member who was concerned that he could never talk to city staff anymore. We know that's not the right answer either. So now it's just going to kind of be where we are on what constitutes an open meeting. Let's start with what we can agree on. We know that the definition of an open meeting was that there was a majority of the board that was either electronically or in person in one place, and there was deliberation or action. So in other words, if they gathered socially and purely talked about social issues, there was not a meeting that did not need to be public notice and all of those kind of things under Chapter 21. Now, obviously, that would draw some attention on occasion. For example, we had a complaint where before a city council meeting, the city council offices were locked up, but people could see the city council members in gathering. And what was happening is they were just getting their computers out, they were getting their materials out, they weren't even talking about business. They were just starting to say hi to each other and seeing each other for a few days or a week or whatever. That's not a meeting because they were not doing any deliberation or action. Similarly, it was election season. People started to get their ward council together. They wanted to talk about how to do their absentee ballot campaign, what to happen. So there was a majority of a council that met somewhere. Again, it was not a meeting because they were not discussing city business or action. Obviously, that's not a best practice and not something we could really recommend people do. It did obviously raise some red flags when you had a majority of a council together, and hard to say that they never slipped into talking about city business. One thing I want to say a little bit before we get into the Warren County decision. Keep in mind and watch out for email. If, in fact, when I communicate with my board, I send an email out, I put myself in the address line and I send a blind copy to all of them so they don't hit reply all. I think the courts have ruled and the Public Information Board certainly agrees that if you start to communicate by email and you have these reply alls and you're talking about government business, you have that kind of contemporaneous communication and you've now triggered an electronic meeting and it should have been noticed and all those kind of things. We have actually had 1 or 2 complaints over the last year and a half that I've been at the Public Information Board on that type of email meeting. So one thing I do want to caution you on, apart from anything else, be careful as you advise your clients on how to handle emails when you're communicating with your boards and with them, and just really not only can you have an electronic meeting, but it also, of course, can trigger some public records, open records issues as well as you try to retain that for whatever your appropriate retention schedule is. All right, let's talk a little bit about the Warren County case. As we talked about, majority of the board gets together to deliberate or act. You have a meeting. For years, there was what was called a walking quorum. For our purposes, I will call it a kind of a serial gathering. And you would have less than a majority of a board communicate together on some issues. Other ones would communicate separately. You never had a majority in one place, electronically or in person, but everyone was kind of talking about what was going to happen behind the scenes. People that are, there's pros and cons to that. Obviously, people like that in some ways because sometimes kind of the dirty laundry was discussed, not out in the open. You kind of knew where the potential landmines were going to be before you ever got to a public meeting, and you never triggered a meeting. I mean, there was never a majority there. It's just kind of everyone kind of understood who the others might be. So you had kind of a series of gatherings. I don't want to call them meetings because there was not a meeting. And then the issue went to the Supreme Court in the Warren County situation. Now, this was filed before I was the director of the Public Information Board. To be honest with you, I wasn't really following the case that closely. I had assumed, and as it appears incorrectly, I had assumed that the court was going to kind of land from a, if this is going to be an open and transparent government, we don't necessarily embrace the practice, but under the current definition of a meeting, it is probably legal and your recourse is with the General Assembly. And instead, the court came down, and again, for my personal take, and I would be interested in how some of you feel and some interaction on this, I think, and let's go from what I think is the simplest answer and work away from there. I think the definition of meeting now means you have a majority of the members of the board or their agents / proxies. Let me say that again. I think what has happened now is that the definition of meeting includes a majority of the members of a governmental body and their proxies or agents. And what happened in the Warren County case, a little bit of what I would call also shuttle diplomacy. You had a member of the Board of Supervisors talking to a county official, and then they would go and the county official would kind of go and talk to another member of the Board of Supervisors, and the Supreme Court kind of found that governmental official, that county official, had almost become kind of a proxy, an agent, and so now that person kind of was empowered to go and talk on behalf of the original board member, and all of a sudden you had a meeting. That's going to be a change of what people have done, are currently doing, and what they think is a meeting. I don't think it's as bad as what some people have said, that we can no longer talk, that the board can no longer talk to their staff. The court clearly said that's not right. You can still talk to staff. I think the issue is, what is the staff then empowered to do or not do? And I know I've had some friends that are upset about this case, that are concerned that board members, especially elected officials, don't have the authority to kind of delegate to an agent. They can't create an agent and a proxy and all that. I don't know. I mean, those are things that are going to have to be hammered out. But I think that as I'm reading it, and again, the Public Information Board will have to weigh in on it. I'll be curious what you guys think, that if staff is empowered in some way and has become an agent or a proxy, that they are now possibly able to trigger the definition of a meeting, depending on if you also have a board member present, and that board member and that agent or proxy would make up a majority of the board. Does anyone, I guess at this point, have anything on that? Is there a different interpretation, a different reading of that? I'm not even sure this case talked about walking quorums, to be honest with you. I think the serial meeting, I think, is still probably permissible. I think we kind of came up with something that we weren't anticipating, which was an agency principal relationship, and didn't even really necessarily deal with the walking quorum, which I think was what we thought the case was going to deal with. I think the walking quorum is probably still okay, depending on if there's a staff member involved and what that staff member's been empowered to do. I can tell you this will change a little bit the nature of complaints, investigations before the Public Information Board. We have not had a complaint based on this particular factual situation yet. There have been a lot of people from the public that have tried to use this court case to kind of argue that the complaint they now have before us somehow is impacted by that, but the facts just haven't matched up, or they've applied the court case in a way that just doesn't make sense. But so we've not had one that's really on all fours with what's going on, but it is going to impact, because now we're going to have to really drill down to was there a staff person involved? What was their level of involvement? What were they empowered to do or not do? What were the nature of the conversations? So it is going to change a little bit our investigative techniques, certainly, to try to resolve these kind of issues. Yeah. We've got our first question, so let me see. I got to put my glasses on with the problems of getting older. Let me see. The question is, what type of delegated authority would be required of the employee would trigger this type of agency? I think that is a fascinating question that we're going to have to sort out. I was not really anticipating at this point in my legal career having to go back and kind of study principal agency law. And I think that's one of the things I'm going to have to do. And I think this is one of the things. What was said to the employee? Was it, and let's start with this. If a board member comes to me and wants information, you know, let's talk about the budget, or wants to talk about an issue, I don't think that I have become an agent for that board member if I go talk to another board member and say, hey, board member A came in, they asked for some information, this is what I gave them. I don't think we're, number one, that we'd never have all those people in the same room, so we're not at issue, but I just don't think that triggers it. Now, if the board member said, I really don't like Project X, let's go talk to another board member and you tell them what we think and what you know, I think now we've gotten closer to maybe shuttle diplomacy. I'm empowered to find out and do things. One of the things in the Warren County case, I think that was on its facts, the staff member in that case and members of the board were very active in creating a plan on how to do some terminations. They made a lot of adjustments to that plan over time. So I think in some ways it's going to be very fact specific on when someone's empowered on doing more than just providing information, and the staff person is taking more of an active role in helping to deliberate or take action on a governmental decision. I hope that helps with that a little bit. This is obviously one of the things that the Public Information Board is going to be wrestling with over the upcoming months, trying to apply this case to, if there are any complaints or there are advisory opinions or rulemaking is asked of the Public Information Board. And I would certainly be interested in anything that any of you have on that particular issue or what you think might happen. My hope is that we will get some opinion requests on some specific factual situations. I know that we have the authority, being Public Information Board, to do a to all interested persons opinion, trying to apply this, but all of you as attorneys for governmental entities giving advice, you would know better than we would in some ways on particular factual situations that you're concerned. Would this trigger or not trigger kind of this agency thing, shuttle diplomacy, someone having the authority to go and negotiate for other members of the board that might trigger a meeting. So I'm going to ask all of you to help us kind of weigh in and sort this out over the upcoming months. Another question. Do you think the case is limited to applying agency principles to staff, or could agency be created with a non-staff member, attorney, or even another board member? I'm not sure that a board member could become a proxy for another board member. That's just me again personally. I think obviously in this type of situation that if a board member empowered the attorney or someone else to advocate, potentially that is a great question. I think people like myself that are both the executive director of an agency as well as providing legal advice, can I really become a proxy for a board member, an agent, if I talk to someone else? I can guarantee you I am going to make sure that I never become the majority of my board present without it being a public meeting, if that helps, just out of safety. I also have an advantage. I have a 9-member board. I think the smaller in number for a board, the trickier this becomes. Obviously, if you have 3 people and all of a sudden a staff member somehow becomes an agent or proxy, and they meet with another board member, they've got a problem right out of the gate. 5 members, slightly better. 7 and 9, I think, is less troubling, but clearly the lower number. I know some people read this case saying it's really based just on the extreme facts of it, but I think all of us do need to be concerned about this notion that a staff member or a non-board member could become part of the definition of the governmental body for purposes of having a meeting. So again, I'd be interested in what others think. Another question. Can you speak to what role a mayor would fall under? Are they a member of the council or the staff, or are they something else? Again, a mayor is an elected official. Can a member of a city council delegate authority to make the mayor an agent? Does it matter if the mayor is able to vote, not vote? I think those are all extremely factual scenarios that we are going to have to straighten out in the very near future on what that person is empowered to do or not do, and when are they just providing information, or when are they kind of engaged in some shuttle diplomacy that might trigger this. I wish I had more answers on some of these. These are great questions. These are things that we're going to have to take back and give everyone written guidance on so that everyone across the state kind of knows and has the same answers. Again, I know I'm repeating myself. Anything that any of you have thoughts that would be helpful to us, that would be very useful, because we're going to struggle with this, to be honest with you, as a regulator, especially given the nature of the Public Information Board. 3 represent government, 3 represent the media, 3 represent the general public. So there's going to be some tough internal discussions on the Public Information Board on how to best kind of apply the definition of meeting as we now have from the court. And I think some of it's really interesting on can another board member be empowered to be an agent, or can the mayor be empowered to be an agent for another board member? And to me personally, I struggle with that, but given what the court kind of said, I don't know. And I think we have to be very careful as administrators of government staff what we do, and make clear with our boards what role we have if we're going to communicate with other board members. If we're going to try to provide information and not kind of engage in shuttle diplomacy and not try to become part of the deliberative process behind the scenes unless there's somehow notice given of those meetings in other compliance chapter 21. It's going to be tricky. I'll be honest with you. And I've spent some time trying to understand the case, and I've talked to a lot of people in the field who want some guidance on this and have some concerns, and I understand it. And I think it did kind of hit all of us a little bit. I don't know that anyone was really anticipating kind of this principal agent thing as opposed to just dealing strictly with the issue of a walking quorum or not. Is there anything else kind of on that point? I know we've not settled anything other than you've raised some very good issues here that are going to have to be hammered out. Is there anything else that any of you would like to weigh in for the group that you think we need to be talking about at this time, or any other kind of issues on that? Otherwise, we'll go ahead and move on. Seeing nothing, please continue, and you have my contact information. If there are other things you want the Public Information Board to think about or other things, send me an email, call me. Think about having your client ask for an opinion request. Let's get some guidance out there in the form of opinions or rulemakings or other thing that kind of help us with kind of this new lay of the land at this point. Remember, as far as notice of a meeting, 24 hours notice in advance, unless there's some sort of emergency. You don't have to do it in 24 hours, or you can change your agenda a little bit, again, if it's an emergency. One of the things that's new, the Public Information Board has an adopted administrative rule that if you are going to have a closed session, that your agenda lists more than just closed session pursuant to 21.5, then a paragraph. They want you to have a few of the buzzwords on why you're going into closed session. For example, let's say it's going to be to discuss litigation strategy with counsel. Your agenda would say, closed session 21.5, discuss litigation with counsel. Just something that gives the public some notice of why you're going into closed session. The Public Information Board thought that it was not fair for the citizens of Iowa to have to look up in the Iowa Code to see exactly why government was going into closed session. So if you're going to do a closed session agenda, if you want to cite the statute, that's fine. Just don't stop there. Just have a couple of the buzzwords kind of to say why you are going into closed session. One of the other things, and this is to implement a Court of Appeals decision from last year, and we now have an administrative rule. If you are going to go into closed session to discuss litigation with counsel, the attorney has to be present. By administrative rule, we said the attorney can be present either in person or electronically. So you do not have to attend the meeting, but if they're going to go into closed session and to discuss litigation strategy with counsel, that you're available by phone, by Skype, by something in person, just somehow that you're actually there. Interestingly enough, we actually have had 2 complaints in the last year. The governmental body was unsure who their attorney was, I don't even know how it happened. I'm not going to bore you with the factual ways that came about, but it was actually two different governmental bodies was unsure who their attorney was. In fact, at one point, one of the governmental bodies went into closed session to discuss strategy with counsel, and the board member said, well, I'm an attorney, so I'll act as their attorney on this, which creates some other kind of issues. So what we have said is for guidance, at some point, make an announcement of who your attorney is. Either get it on the minutes, have a contract, do something where the public is aware of who the lawyer is for the governmental body. I thought I would never have to say that. We've actually seen it twice in the last year where the government just didn't know who their lawyer was. So, clean that part out. Remember that the posting of the notice just has to be physically placed where you normally have all sorts of notices, and you also have to let the press know if they've requested it. You have to send it to the press if they've requested notice of your meetings. Obviously, best practice if you want to put it out on social media and all of that kind of stuff, but you don't have to do it. We'd love it if you did, but you certainly have to at least post the notice at a place where it can be seen, post it 24 hours in advance. Again, unless there's, and the agenda has to give the public reasonable notice of what's going to happen at that meeting. If there's some sort of an emergency, you can adjust your agenda. However, please communicate with the Public Information Board staff if you're anticipating adding an item with less than 24 hours notice. That is something that will draw a complaint from the public, and then if it's an emergency or not, it's just something that we need to flesh out. Obviously, it's not an emergency if you could postpone the decision for a special meeting and notice your meeting and do all of that kind of stuff. Sometimes it's truly going to be an emergency, but it's just easier if you communicate with us up front so we kind of know your situation, can kind of help walk through, well, it's maybe not truly an emergency. You could wait to your next meeting or hold a special meeting, all of those kind of things. If for some reason you can't post the notice where you normally do, we've adopted an administrative rule that says, like you're doing some remodeling, reconstruction or something else, that you can post the notice somewhere else temporarily where other type of notices would be posted. Do not do what one governmental body did. It was going to have a special meeting. It posted notice 24 hours advance. It posted it in an office where it never posted anything else before, and that office was locked for most of the 24-hour period. That will not really comply with the 24-hour notice requirements. Don't do anything like that if those types of situations come about. One of the other things for meetings I know we've struggled with, and for some of you we've talked about this, how we're handling advisory committees, subcommittees, those kind of things. When are they truly advisory and not subject to 21? What does the Warren County case do? We're going to be getting some guidance out this summer, kind of dealing some more with that advisory committee, the subcommittee issue, especially with this new court case. So I don't want to dive too much into that. You guys know some of the struggles that we all have with how the law is applied in that type of situation. One thing that's come up a lot, I want to remind you, there is no mandate in the open meetings law to allow for public comment. We get that question a lot. I just had it today, this morning in fact. There's nothing that mandates a public comment period during your meetings. I also had the question last week, was there anything in Chapter 21 that mandated that government notify the public that a meeting is going to be recorded? I could not find anything that mandates that. Obviously, closed session has to be audio recorded. That is in the law. We're going to talk about closed session a little bit. And there is a statutory provision that the public may record a meeting, and obviously the statute also grants governmental bodies the authority to regulate conduct at meetings. So if somebody was holding a camera right up in front of somebody's face, you could have rules that mandate they be so far back and other kinds of things like that. We occasionally get issues where the public's wants to record, where can the recording devices be, how invasive can they be? So just kind of heads up on that, but you certainly have the authority to regulate that type of conduct. One of the things I do want to point out that's changed a little bit, it's kind of an interplay between open records, open meetings. One of the newest exceptions to the open records was the draft document, that while a document was in the process, it had not been submitted yet for kind of final approval by a final authority, that it was a draft document. The problem was, in the complaint that we had, this draft was being submitted and presented at a public meeting, and then the governmental body was taking it back saying, well, we're going to work on this some more, and so it's going to fall back under the draft exception. The problem was they had already presented it and had it viewable at a public meeting. The Public Information Board has said that once a document has been presented to the public and viewable by the public at a meeting, that you can no longer use that draft exception. I know I'm kind of dancing back and forth between records and meetings, but that is something that triggered my brain here quickly. Let's talk about closed session for just a little bit. 12 reasons under the statute that you can go into closed session. We talked a little bit about notice. Make sure that your agenda, again, does more than just says 21.5, that you give some buzzwords of why you're going to go into the closed session. Statute requires closed session be recorded, and that audio recording be maintained for 1 year. So make sure you have some sort of system where you can access that closed session for a year. An issue that we're dealing with, and again, I would appreciate some of the input from all of you, there's some questions about who can access that sealed audio tape. For example, you have a board member who missed a board meeting. Can they go back and hear that closed session tape, or do they have to go get a court order? I think the staff, the board itself is not ruled on this, but I think at the staff level, we're comfortable that if it's a sitting board member and they were entitled to be part of that closed session, that they can go ahead and hear it and not get a court order. I know some people have raised the issue, what happens if someone is now on a board and they want access to a closed session prior to them becoming a board member? And again, at kind of the staff level, we're not comfortable that they're entitled to that. I think that is going to be an issue that we are going to try to get some guidance to all of you on this summer and fall. So if you understand the situation, somebody gets elected, they get put on a board, and they want to see some closed, or they want to listen to some closed session tapes that happened prior to their election. Are they entitled to them, or do they have to somehow go to court and get that unsealed? At the staff level, I think we are of the point of view that they are not entitled to hear those closed session tapes. Again, the board's not weighed in on that. That is just kind of what guidance we're giving at the staff level. We will get some written guidance on that to kind of help people out. I know that you get some people elected to some of your boards, and the very reason they want to be elected was they want to deal with something that they weren't necessarily privy to before. So we're going to have to sort that out. Obviously, no action can be taken in closed session. All has to come out announced in open session, any final action, and all of those kind of things. But I know some people sometimes want to hear what was said in closed session. Remember that conversations in closed session must be strictly on the reason why you went into closed session. Occasionally we'll get a complaint from the public where they think that a conversation's been had on a different topic. We do have the statutory authority to get that tape and listen to the closed session. So far, government has been in compliance, but I know it's hard. Most of my career I've had to advise boards. I know it's hard when they get in closed session. They want to let their hair down. They kind of just want to talk about everything in the world, but make sure that they stay on message and on topic, that it's why they went into closed session. Keep their conversations limited to that particular topic. Any questions so far on closed session meetings, anything like that? I do want a couple of law changes from this last legislative session. One is effective July 1, you can no longer, well, let me back up. Apparently there was a governmental body that was somehow excluding one of its own members from closed session. There is now a law in the books, effective July 1 of 16, that says you cannot keep a member out of closed session unless that member has a conflict of interest. Okay, so I don't know all of the factual background that triggered why we have a law now, but apparently there was a local council that was trying to keep a member out of closed session. The Public Information Board, by administrative rule, has said that it's up to the governmental body otherwise to invite in whoever it wants to in closed session. We had someone from the public that was trying to complain that a governmental body was allowing governmental staff and others into a closed session. We have said it's up to the discretion of the governmental body of who they want in, going back to, of course, if they're going to discuss strategy with counsel, the lawyer has to be present either electronically or in person, but otherwise government can let in whoever it wants to at its discretion, but now it cannot keep one of its own members out unless there is a conflict of interest. Okay, so that was something that was brought up this last session, will be law July 1. Also with some notice, another law that passed this year, if you cannot, or for whatever reason, you schedule a meeting and through no fault of your own, that meeting has to get moved back, you can publish notice as soon as you know about that and still be in compliance with the law. And here's kind of the situation where this covers what happened. A governmental body finds out at 9 o'clock in the morning they have a controversial issue and they want to move meeting locations. Instead of at least having the meeting start at one location saying, okay, we're now going to move to another location, giving people time to go over, they didn't do anything. They just moved their meeting, didn't tell anyone, okay, because they wanted to go to a bigger facility. Obviously that caused a problem. The law now would allow them to either post immediate notice and then go ahead and open that meeting and then move over, but do something, and the law was intended to cover and be another tool for government, not a bad thing. So if this comes up in the future and you know that you're going to have a problem that night, you've got to move your meeting for some reason back because of time or there's weather, there's something else, post notice right away. When the meeting time starts and at that location, have somebody there, open it up and say, hey, we're going to have to move it, okay, to another location. Give people time to get over there. Or if worse comes to worse, obviously you can just move it to another night and renotice the meeting. So that the new law is written in kind of a little bit of a funny way that we're going to have to sort out a little bit, but it was intended to help government as far as this notice requirement. Is there anything else on open meetings? Any questions that any of you have at this point? The majority of complaints that we see in this area are kind of things that we've already covered a little bit. I think just notice your meetings, keep your minutes, make sure that the agenda is descriptive enough. Don't just say, don't have an agenda that just says old business, new business, nothing else. Make sure that you are listing out the room the meeting's going to be had, those kind of things. How are we doing on time? Are we okay?
We have about 20 minutes.
About 20 minutes. Let's talk about open records for a little bit, and then any questions that any of you have. Some of the issues that the Public Information Board has really been dealing with, one involves fees for records. As you know, the law talks about the fact you can assess a fee for some reasonable costs or some things that you're absolutely not allowed to bill for. One of the best practices, I guess, that we've kind of adopted, communicate with the requester. Let them know up front what the fee is going to be. If you're going to collect the fee, which you can do up front, that's okay, but just really communicate with the people. Where we've seen the biggest problem with open records issues, government's just chosen to ignore, for whatever reason, the requester. Don't do that. Communicate with them. Let them know that it's going to take some time. Maybe they put a very large request in. It's going to have to be reviewed by counsel to make sure that there's no confidential information in there, which is perfectly permissible for you to do if there's a question about whether or not there's going to be confidential information. Just communicate with the requester. You cannot ask them why they're requesting the information, but you can certainly communicate with them on if they want to submit what I would call a more pointed request so that it can reduce their fees, your time. For example, the other day someone called and they had made a request that they wanted all emails from the last 10 years that had certain words in there that it was going to be a massive request. I'm not even sure the city would have even maintained all those records for all that time, but in any event, that was a perfect situation for them to communicate with the requester and try to simplify the request or make it more pointed so they weren't just asking for something that was going to cost them thousands of dollars, and it was just way beyond what the person even really wanted. But so whatever you do, I'm imploring you, make sure that you communicate with the requester, be upfront so everyone understands what the fees are, what they're for, that the fee is reasonable. Like I said, the Public Information Board's been struggling a little bit, or not struggling, but wrestling with how to give some guidance on what's a reasonable fee. And I know some people want to do kind of a standard charge. I can tell you charging $1 a page for photocopies is not reasonable. Okay, there was a state agency that wanted to charge $1 a page. I mean, be reasonable in your fee assessment and talk to people. If you have questions about whether or not information is confidential, I really encourage you, and the Public Information Board staff does spend a lot of time trying to help government determine whether or not a record should be disclosed or not. And that's kind of one of the services that we provide. And it's been very useful to be able to work up front and avoid some complaints by being able to say, yes, we think that is something that probably should be disclosed, or no, we agree that that is a record that can be kept confidential. I know that for those of you that are dealing with law enforcement situations, there is a contested case that's going on right now before the Public Information Board. One of the exceptions to the open records laws deals with peace officer investigative reports. And there was a very unfortunate situation that happened in Burlington, and the body camera video of the law enforcement officer was requested. And we are dealing right now with, should that be part of a peace officer's investigative report and remain confidential despite the fact that the investigation is over, or should that be disclosed to the newspaper and one of the members of the family? And I don't want to go into much more detail on that because, like I said, it is under litigation right now, but we are dealing with technology and how do you deal with that in the future. Police body cameras, dashboard cameras will be something we have to sort out. I mean, clearly we're moving beyond just paper documents. One thing the Public Information Board has said, you are not mandated to create a record. If you have information in your possession, they request the information, you need to provide it to them, but you are not mandated to create a record. And that's a very factual, specific situation. But if you get something like that, please communicate with us on what exactly it means to whether or not you have to create a record. One of the interesting things about confidential versus public records, as you look at Iowa Code Section 22.7, which is talks about what records are confidential. The lead-in paragraph to that section says that court may order a record to be opened up, or the lawful custodian seems to have some discretion. However, The courts have not necessarily ruled that the lawful custodian does have discretion. I mean, there's some of those exceptions, and I think we're now up to 69 or 70 exceptions in 22.7. Courts seem to rule that some of those are absolutely have to be kept confidential. So again, contact and communicate with IPIB if you have a situation where you're concerned about what you can release, not release during the pendency of your open records issue you're dealing with. Keep in mind that records are supposed to be produced as soon as possible. There's some language about 10 business days and 20 days. There's a court ruling that kind of talks about that is to determine whether or not a record is confidential, if there needs to be an injunctive relief and all of that kind of stuff. I would say that if you're communicative with the requester within 10 days in a complaints filed, you're going to be okay at a maximum of 20. But again, if you're able to provide the record sooner, please provide it as soon as you can. One thing I would caution, especially local governments, about is some sort of retention schedule on how long you have to keep records that you then would that are subject to a FOIA request later on. For state agencies, the State Records Commission has some guidelines on how long government has to keep certain records, and there's retention schedules and series and all of that kind of stuff. Doesn't apply to local governments. I would encourage you, those of you that advise local governmental bodies, think about a retention schedule so you know exactly how long you have to keep certain records, how those are retrieved. I think that will just make your life easier. Public Information Board does not get into record retention. We just deal with whether or not, if the record exists, if it's confidential or a public record that should be released right away. But for those of you dealing with some of those issues, you may want to work on some retention schedules. Really, the biggest thing with open records, I mean, all of you can read the statute, and you've dealt with this stuff for years. Fees, we're going to straighten out. Try to get to the requester as soon as you can. If you have any questions on whether or not it's a public or confidential record, obviously the governmental body needs to talk to their attorney, which are you guys, and then loop the Public Information Board in as soon as you can. Let me talk just briefly a little bit about the complaint process before the Public Information Board. I know that was a concern when the board was created. When we get a complaint from the public, the first thing the staff does is get a copy of that complaint to the governmental body. We try to get it through the attorney if we can, but we try to communicate and get that as soon as we can in the hands of the governmental body for a response. We call this the staff review portion of a complaint. We want to know your side of it. It's amazing at how many times that takes care of the matter. We understand where you're coming from. We get the other side of the story. What happens at that point is a proposed decision is drafted and submitted to the board on whether to accept the complaint, which means, well, I'll deal with acceptance in a minute. Accept the complaint or dismiss. The board then has the decision to either accept that proposed decision or not. If the proposed decision, the board agrees to dismiss the complaint, the matter is over with, pending the fact that, of course, the complainant could request judicial review under Chapter 17A to district court. If the board votes to accept a complaint by statute, and it's kind of a unique statutory provision, it says that the board staff is to work with both parties towards an informal and expeditious resolution. That's written right in the statute. The word to try to work with both parties to see if we can come to some sort of an agreement on how to proceed. Much easier in the area of open records and open meetings, obviously. I mean, it's pretty tough to somehow come to some sort of expeditious and informal resolution of something that happened at a meeting where someone thinks that a meeting shouldn't have happened or there was something closed session. I mean, that's a little trickier, but anyway, that's one of our requirements. If we cannot come up with an informal and expeditious resolution, that often means IPIB staff is kind of helping, trying to mediate the matter. And then by statute, we are directed to investigate the matter and bring back a probable cause report to the board. The board then has some options of either moving forward with a contested case, finding probable cause but dismissing the matter, or finding that nothing happened and closing the matter out. One of the things I would encourage you is when we contact you at that first stage, just please be thorough, communicate with us on your point of view, any arguments you want to make up front. That is very, very helpful. Sometimes we've seen some government bodies that just don't want to cooperate at that front end. They're mad at something or who knows, and that's just detrimental to the process. Just communicate, let us know your take on it. We then have to work with that, obviously, on whether or not to accept or dismiss and what we recommend to the board, but it's just useful having that kind of upfront information for us to work with. There's only been 2 or 3 matters in the existence of the Public Information Board that have gone to a contested case. Most of the things we're able to work out informally, or they end up being dismissed up front because they are not, they're not with merit. So we've not had a ton of litigation, clearly, or it's not a board that's trying to over-regulate or wants to penalize. They actually want to work with people as much as possible up front. So that's kind of some of with the complaints and whatnot. We've got a general question. Non-public citizen participation in public initiatives, for example, the Iowa Energy Plan working group participants, what email communications are considered public records? I would say this, that if you are having those types of communications, they are in possession of a governmental body and they are not subject to a clear exception. I think they are public records. Any kind of situation like that. Whenever you're getting a communication and the communication's in your possession, relates to governmental business, and an exception does not apply, that's a public record, needs to be dealt with. So again, in those types of situations, please contact the Public Information Board staff and say, we've gotten a request on this. It's kind of the factual background of it. We'll work with you to determine whether or not that is truly a public record or it fits within one of the many and various exceptions that exist out there, and there are a lot. Remember, emails are records. I mean, just like any kind of paper thing. So it's a record that you have in your possession in any sort of format, and make sure that you're somehow keeping your emails, if they are truly public records, within your retention schedule. How much time? How are we doing for time? We have about 7 minutes. 7 minutes. Any other questions on anything? Especially going back to the case out of Warren County. If any of you have anything you want to weigh in on that at this time. Trying to think if there's anything else that's new or that's changed a little bit this legislative session. I have not heard yet about any initiatives to try to deal legislatively with the Warren County decision. I think people are kind of still trying to read, get a full grasp. I mean, just from some of the questions you guys raised today, which were great ones, as far as who has the authority to delegate agency, who can be an agent for each other, how do you treat it, especially with the elected officials? At what point does a board or a staff member, have they moved beyond just providing information to when they talk to other board members? Are they somehow doing shuttle diplomacy? Those are all great things that we're going to have to deal with, and we're going to deal with them sooner rather than later. One other thing I should say about the complaint process a little bit. Public Information Board does not have jurisdiction over the legislative branch, does not have jurisdiction over the governor's office, and has a 60-day statute of limitations. Let me say that again. By statute, the Public Information Board has a 60-day statute of limitations. So a complaint must be filed within 60 days of the alleged conduct, which would be that there was an improperly held closed session, or there had to be some sort of meeting that actually occurred that wasn't noticed, or notice wasn't done correctly. For a public records issue, it would be 60 days from probably denial of the records request, or that there was not sufficient records produced, but it's a 60-day statute of limitations. So for IPIB to get involved, it is a pretty narrow time frame that we were able to take action on a complaint. It's 60 days from the time of the alleged conduct. So that cuts out a lot of complaints that we get just from a purely time-sensitive issue. So keep in mind that there is that 60-day, and we're very cognizant of it. So that's been helpful in some ways with some of the stuff that we've dealt with. And we really do try to work out as much as we can an informal resolution of a complaint between the parties. Obviously, there's some of the exceptions in the confidential records, public records, that we're going to have to sort out a little bit. Law enforcement body cameras, one that I've talked about. There's some other ones that come up a lot. Personnel, what you can keep in a personnel file. Also, let's jump back. I'm sorry to jump back to closed session for a minute, because this is one that's often missed. You can have a closed session to discuss the hiring, firing, professional competency, promotion, discharge, all of those things, dealing with a governmental employee, if it would irreparably damage and harm the reputation of the person and the person requests it. So if you are getting ready to deal with a personnel matter, the board is, that person has to request that it be done in closed session, and there has to be a situation where it could do some irreparable damage to their injury or reputation. I would suggest as a best practices, you have that person put in writing that they are requesting the closed session. We actually saw a situation where the governmental body held a closed session. The employee said, well, I never requested it, filed a complaint with the Public Information Board, and the governmental body actually had kept a copy of the employee's request for the closed session. So why the person ended up lying to the Public Information Board, I don't know. That was just kind of a weird situation. But I would say as a best practice is make sure that that person puts in writing that they're requesting going into a closed session because they're worried about their reputation being irreparably damaged or harmed. With that, again, please take a look at the website. We have a lot of information out there. Our administrative rules, we've been doing a lot of work on those in the last year to try to give more guidance, especially in the area of closed sessions and meetings. We're doing more advisory opinions, again, trying to apply the law and rules to a specific factual scenario. We will be getting a lot more information to you dealing with the case out of Warren County, and any thoughts that you guys have on helping us kind of with some of your very specific factual situations. You've got some good ones today that I'm going to copy and take back, would be very useful. And again, just if you have issues, we really are trying to run the agency in a way to work with you up front, not to play gotcha later on or have to deal with complaints, but trying to provide some guidance up front. We do monthly columns on giving some guidance on what's open and what's not. We try to get some Attorney General sunshine advisories out in people's hands. We really want to get as much information as we can to you. And I believe that pretty much is our time. Do you have any final things?
Yeah.
Record keeping?
Do you want to give everybody your website address just in case they don't have it? They should have it in the...
Yeah, if you want to look on, the question that came up, what is the IPIB's website? If you look on the bottom of page 5, it's actually going to be numbered paragraph 6 will have IPIB's website, which will also have all of our contact information. So it's a really great resource. Thank you all for your hour of time, and you had some fantastic questions that are going to create some work for me, which is a good thing. Thank you.